very happy to be here today on a beautiful day in Basel with you. I understand you came from all over the world to attend this school, and I'm very honored to be speaking as the keynote lecturer of this School of Arbitration. So my presentation deals with the evolution of authority in international arbitration from relations to rules. And it is basically the result of some years of research about the evolution of international arbitration and the ways in which authority in international arbitration has evolved, okay? This research has a historical component, as you will learn. It will be probably very different from other lectures you have heard, which might be a little more about the law, the substantive content of arbitration law. But I will ask you to consider this analysis with an open mind. So the first step of the analysis is really an observation that is well known, I suppose, to all of you, which reflects the success of international arbitration over the past few decades. And some figures illustrate this success. So in this presentation, I will take two case studies to illustrate what I call this evolution of authority from relations to rules. Two case studies which I'm sure are very well known to you. One in the field of international commercial arbitration, the International Chamber of Commerce, which is based in Paris, and the other one in the world of investor-state arbitration, the International Center for the Settlement of Investment Disputes, which is based in Washington, D.C., and which is also one of the agencies of the World Bank. Okay, so I assume you all know that. What you see on the slides in front of you are the number of cases in the past few decades submitted to these institutions. And what we see very clearly is the expansion, very steep expansion in the number of cases submitted to the ICC on the left, and to investor-state arbitral tribunals on the right. And you can see in light gray the cases submitted to the ICSID, to the International Center for the Settlement of Investment Disputes. So the question is, as arbitration became more successful, did the authority of arbitral tribunals evolve in a particular way during all these years? Has the success of arbitration modified the shape in which the authority of arbitrators, the shape in which arbitrators exercise their authority? Okay. And to analyze this question, I use a model which is probably unknown to you, which I draw from the work of an economist, a professor of economics, and a game theorist from the University of Princeton. His name is Avinash Dixit. You see a picture of him on the left, and he wrote a couple of papers and books on this issue that I would like to highlight, this model that I will apply to the evolution of international arbitration, both commercial and investment, in the past few decades. So you have a few references in front of you. One is his book titled Lawlessness and Economics, Alternative Modes of Governance at Princeton University Press. And there is a companion piece, which is a shorter article at the American Economic Review, Governance Institutions and Economic Activity. So in these papers and in this book, Dixit draws a kind of model. He distinguishes two types of governance systems, and these are pretty easy to understand. So don't get scared and don't leave me too early, okay? This is very, very like intuitive what he's saying. So if you read the book, you'll see there are lots of equations. It's very complex, but in the end, it boils down to very simple ideas, okay? So on the one hand, he describes a system which he calls a relation-based system of governance. And on the other hand, he describes what he calls a rule-based system of governance, okay? So let's listen to what Dixit says about each model. On the one hand, and I'm reading the slide in front of you, he defines a relation-based system as a system that has little or no fixed costs. One starts by dealing with close friends and neighbors, but as business expands, one must deal with strangers and must first establish relationships with them. Therefore, the marginal costs of expansion are high and rising. Okay, so I'll walk you through an example to understand what this really means. But in other words, it captures the situation in which a small group, in which individuals interact and trade in a small group, and basically govern their relationships through peer pressure, information sharing, retaliation, and so forth. So that's the first model. I'll try to illustrate it with an example later on. The second model, which is the rule-based model of governance, is defined as follows. A rule-based formal legal system requires substantial fixed costs to pass the laws and to establish the courts to adjudicate disputes and a police force to enforce the court's verdicts. But once the system is in place, people can deal with strangers in relative confidence, so the marginal costs of expansion are low. So what Dixit is describing here is a system that is a formal legal system that is costly to establish, but once it has been established, it is a good system to govern many different people. Unlike the other system, which is very informal with very low costs, but only work, according to Dixit, if the society that it governs is rather small. Okay, so of course, these are ideal types in the Weberian sense, and you will probably not find them in such a pure way in society, but it helps us understand the ways in which systems of governance, such as arbitration, has evolved in the past few decades. So I promised an example to try to see in more precise terms what Dixit means. And here is an example. So imagine two young women living in a small village. Okay, so this is my work product, my art. So please admire my skills. So you see a small village in Switzerland where two women exist, and these women engage in trading. Okay, they sell things to each other, and they know each other very well. Okay, this is, according to Dixit, a relation-based system of governance. So I've named these two young ladies, Florence and Nicole. Florence and Nicole are very unlikely to turn to a court or to turn to a legal system if they have a dispute. What they will be doing, however, is to gossip about each other or to retaliate by telling their friends, which they have in common, that, for instance, Nicole did not comply with a part of the deal. Okay, so immediately I can picture exactly what this is. I mean, we see that in everyday's life. And this is a rather simple situation. But let's make the situation a little more complex. And let's imagine that Florence and Nicole do not live in the same village, but they live in two neighboring villages. Okay? So we can imagine that they have friends in common, they know each other, but they don't know each other as well as in the first scenario. And because of that, sharing information about their reciprocal behavior is more costly. Okay, so you see that the costs of this system are growing as the system becomes more complex and spreads over a larger territory. Okay, so let's add another twist to the model. And let's imagine that Florence and Nicole are living in two Swiss villages, but these villages are not neighboring villages. They are separated by other villages, okay? And you immediately see what I'm trying to establish here. It is even less likely that they have friends in common, that gossip can be effective as a mode of governance, and as a consequence, the costs are going to keep rising, okay? What happens if Florence and Nicole have a dispute? It is likely that in this scenario, they will talk to their friend Arne. Arne lives in the third village that is in between Nicole and Florence's respective villages. And because he's a neighbor of each village, he has connections with each village, and as a consequence, is able to transmit information if Nicole or Florence are breaching the deal, okay? He's playing the role of an enforcement intermediary, okay? So we'll elaborate on this idea of enforcement intermediary, but what you see here is that Arne is a quasi-institution, is a quasi-judicial institution, which can be associated with some costs. So Arne could work for free, but he could also ask Florence and Nicole to pay him a fee to solve their dispute and to facilitate their trade. You see that the costs are rising. The costs are constantly rising as the situation becomes more complex and the trading relationship expands over new territories, okay? What are the predictions made by Dixit? Dixit predicts that honesty declines as the size of the world grows, okay? This is something that could be tested empirically. And the second prediction is that relation-based governance, the one that you see in the small village, gives way to rule-based governance, the one introduced by a third party like Arne, as economies become larger and more globalized. All right, now let's see how it applies to international arbitration. You must be wondering, what is he talking about? You know, I just want to go home. It has been a long week. And here's this guy who talks about Arne, Nicole, and Florence in small villages of Switzerland. If we take a look at the evolution of international arbitration, the ways in which it emerged, we see very strong traces of the first side of the model, the relation-based model of governance. And we see that, for instance, when we look at the ways in which the institutions that I told you about emerged. So the ICC Court of Arbitration and the ICSID, the International Center for the Settlement of Investment Disputes. What we see is a reality that is very different from the narrative that you will usually hear about arbitration. Namely, the narrative according to which these institutions have been so successful at generating cases. They have been so successful at driving the development of international arbitration. What I observe is that simply these institutions have formalized systems of dispute resolutions that existed before them, and they have formalized the demand that came from the market itself. So let me show you, for instance, the case of the ICC. The ICC was created in 1919 after the First World War and after the Treaty of Versailles, at a time when there was this idea, which still is very strong today, that peace could be promoted by increased trade and prosperity, okay? But at the beginning, the ICC, and I'll come back to that point, didn't have anything to do with arbitration, okay? It was kind of a United Nations, or at the time, a League of Nations. It was the kind of equivalent of the League of Nations for international business, for international trade. It was a place where businesses, traders, banks could meet and discuss their respective issues. Very shortly after its creation, however, banks, particularly banks and businesses, came to the ICC and asked the ICC to solve disputes that would arise between them. And it is only because these businesses came to the ICC that the ICC created the system of international arbitration that made it so famous, okay? Which is a kind of interesting paradox. Today, the ICC is much more important for its arbitration services than for anything else, okay? In 1922, 1 year after these cases started flowing, the ICC adopted rules of conciliation, in parentheses, good offices, and arbitration. And please note the order, the sequence of each system. Conciliation comes before arbitration. That's something very important to keep in mind, and I'll say a few more words about this in a minute. In 1923, the ICC created its Court of Arbitration, which is actually not a court, but simply a kind of entity that supervises the arbitration proceedings that are submitted to ICC tribunals. In other words, the practice of ICC arbitration antedated and was the main driver for its institutionalization. So you may say, okay, so far so good, what about ICSID? The story of ICSID is very similar. The way ICSID was created is through the Washington Convention of 1965. That's a very well-known story. But what happened before the Washington Convention is not as famous. What happened is that the World Bank was involved, as you know, through the IBRD, the International Bank for Reconstruction and Development, in lending money to developing countries. That's still the main activity of the World Bank. What happened is that foreign investors and states came to the World Bank, came to some of the top executives of the World Bank starting in the 1950s to ask these executives to solve disputes that arose in different parts of the world. So I've listed a few famous examples on the slide in front of you. One is in 1951, when the Vice President Robert Garner of the World Bank was called to mediate a very famous dispute between the Iranian government and the Anglo-Iranian oil company after the nationalization of what was at the time the largest oil refinery in the world. In 1956, another dispute was submitted, this time to the president of the World Bank, Eugene Black, and this came after President Nasser nationalized the Suez Canal Authority, and that English and French investors tried to get their money back. They turned to the World Bank in order to do so. This is at this point that the president of the World Bank decided to launch an effort to create what they call the machinery of investor-state dispute resolution. And you see that in an address from President Black to the annual meeting of the Board of Governors of the IBRD in Vienna in 1961. Quote, "The fact that governments and private interests have turned to the World Bank to provide this assistance indicates the lack of any other specific machinery for conciliation and arbitration. Note again the sequence: conciliation first, arbitration second, which is regarded as adequate by investors and governments alike. I therefore intend to explore with other institutions and with our member governments whether something might not be done to promote the establishment of machinery of this kind." This led to the signature of the Washington Convention in 1965 and the creation of ICSID. That's a better known story. What Black said is that the Washington Convention, I quote, "institutionalizes the bank's present dispute settlement activities." So once again, the institution is playing catch up with the market. It's not the other way around. It's not the institution creating a market for arbitration. It's the market creating the need for an institution. That's quite an important point that I would like to make. Why these institutions? And that brings us back to our system, to our model with the relation-based governance on the one hand and the rule-based governance on the other hand. The ICC, before it created the ICC Court of Arbitration, was basically a network. It was a network made famously of national committees. So there is, for instance, a national committee of the ICC in Switzerland, but there are many ICC national committees in hundreds of countries. And these national committees are in charge of establishing ties with local businesses, banks, trade federations, and to basically share information and send it back to Paris, where the headquarters of the ICC are based. It is in some ways an equivalent of ARNE in the example I gave earlier. It is an institution that is central and that is situated at the intersection of several networks. In 1935, the ICC described itself as, I quote, an institution in close touch with all the great industrial and trading industries in the world, with membership from all the most important economic bodies in the world, end of quote. So you see why companies came to the ICC to solve disputes. They wanted to tap into this network of relations that the ICC had with local businesses in order to solve their disputes. And I will show you in a minute how this need was reflected in the rules of ICC arbitration that developed over time. The ICSID was at the core of the World Bank, and the World Bank had a kind of similar position. Of course, the World Bank has always had a very substantive activity, which is the lending of money to capital importing countries, but it did more than that. When it lends capitals, it monitors the activities of capital importing countries. And for instance, in 1961, President Black testified to this monitoring activity that is, again, very close to what ARNE is doing with Nicole and Florence in our small Swiss villages. At the time of the Congo situation, Nasser, so the president of Egypt, seized all Belgian properties as a retaliation for what happened in the Congo. I've sent word to him and his government that we are not going to make any loans to them now until they settle with the Belgians. We won't lend money to any country that seized property until they make proper payment. What the World Bank is doing here is to share information and to put moral pressure on an actor who is seemingly not complying with some rules of international law or other rules, okay? So let's take a look at the early rules of the ICC and the ICSID and the ways in which it can be deemed to relate to this system of relation-based governance. In 1922, when the ICC created its rules of conciliation, good offices, and arbitration, it insisted that disputes should be settled without recourse either to the courts or to arbitration properly so-called. That's a huge paradox. Now the ICC is so famous for its system of arbitration. When it created its rules of conciliation and arbitration, it didn't want parties to go to arbitration. It wanted parties to turn to conciliation, okay? You know the difference between arbitration and conciliation. Conciliation involves a third party, but this third party is only here to facilitate the settlement of the dispute. The third party is not here, unlike arbitration, to issue a binding decision, okay? It's a much lighter form of dispute settlement method, one that is, again, closer to what ARNE does in our first example. In the period between 1923 and 1928, a majority of cases submitted to the ICC were solved through conciliation, 71 against 12 arbitration cases. And the ICC actively promoted conciliation as a mode of dispute resolution. They did not believe in arbitration. They wanted to promote a low-cost system of dispute resolution based on the understanding that they could make this system work because they stood at the middle, at least in their view, of a network of businesses that could put pressure on different actors to make this system work. 1935, the more conciliatory the parties show themselves, the more likelihood there is that they will remain on good terms and continue to do profitable business together in the future, says the ICC in one of its marketing material of the time. 1954, we're moving forward in time, but still you see traces of this early model. Conciliation is always, always to be preferred to arbitration. ICSID has a slightly different story, but you see traces of a similar kind of attention paid to conciliation as a mode of dispute resolution. It is not as clear as the case of the ICC, but please keep in mind that ICSID was created and had its first cases about 50 years after the ICC had its first cases, 1921, 1971, or 70 for the first cases submitted to ICSID. The ICSID Convention, the Washington Convention, has a section which is often forgotten for a very good reason. It has almost never been used, which is Section 3 on conciliation. In 1973, the founder of ICSID argued that conciliation may, in certain situations, be preferable to arbitration. It reflected the policy of the institution, which was strongly in favor of conciliation instead of arbitration. Again, in 2004, and this is closer to today, ICSID tried again to promote conciliation and again failed. The center now actively promotes conciliation as a relatively low-cost, interesting, low-cost alternative to arbitration that may better preserve business relationships between the parties. On receipt of a request for arbitration, ICSID calls the attention of the parties to the conciliation alternative, which means whenever a party sends a request for arbitration to ICSID, the response of ICSID sends a letter back and says, okay, thank you, we acknowledge receipt. Please keep in mind that we have a great conciliation service that you can use. And in effect, almost no parties turn to the conciliation service of ICSID. So we see the early emphasis placed on conciliation as a sign that these institutions wanted to tap on a network, wanted to tap on a system of relation-based governance. But we see other traces that are even clearer in the case of the ICC. And I'll give you 3 examples. I could multiply examples, but I will just focus on these 3 examples that are more salient. One is the enforceability or the enforcement of arbitration clauses or arbitration agreements. So you all know today that there is a legal framework in most countries, that the New York Convention has a section on arbitration agreements, and that it's a non-issue. In 1924, and for a long time, the ICC, the official position of the ICC was, you should comply with arbitration agreements because otherwise we're going to ask the companies we know to stop trading with you. It was pure moral pressure, okay? So here is a quote that reflects this position. Anyone who signed this arbitration clause and attempted to repudiate his obligation by refusing to accept arbitration by the ICC when a dispute arose would be subjected to pressure on the part of the ICC and of the commercial organization, whether national or local, to which he belonged. Okay, so the idea here is to tap on this network, put pressure on a party that doesn't want to comply with arbitration agreements. Another example, the sociology of arbitrators. Okay, so earlier I told you about Arne. Arne knows Nicole and Florence, is close to them. Okay, that's the reason why he's selected by them in the first place, because he has relations with each of them. Okay, it was a little bit the same at the beginning of commercial arbitration in the case of the ICC. So I've done a study of the arbitrators appointed to the ICC between 1922 and 1973. So the first 50 years based on the archives of the ICC. I couldn't go further because for confidentiality reasons, I didn't have access to more recent archives. What we see is that at the beginning, the vast majority of arbitrators were traders, heads of companies, bankers, people who basically were close, who had expertise and knowledge of the business that was at stake in the dispute. Over time, we see the emergence of a new type of arbitrators who have legal training. So either lawyers, law professors, former judges or current judges. So we see a kind of evolution from people who, in the words of the US Supreme Court, I'm citing a case of 1965 of the US Supreme Court, were men of affairs. At the time, it was like pretty clear they were like almost only men, not apart from, but of the marketplace. Okay, why is it so important to notice that? It is important because these people had a very different kind of way of handling disputes than lawyers. Okay, what is also quite noteworthy is that they worked for free. They didn't charge fees for many years. And of course, things have changed quite dramatically in the past decades. I would like to see how an arbitrator would react if he or she were asked to work for free. Okay, at the time, it was considered to be a service given to the community to which they belonged, a kind of relation-based kind of dynamic. Okay. Third topic, the enforcement of awards. Nowadays, it's again a non-issue because there are all types of legal frameworks ensuring the enforcement of arbitral awards. At the time, the position of the ICC was that the parties are, and these are the rules of arbitration of the ICC, are in honor, that's an interesting word, right? Bound to carry out the awards of the arbitrators. And if they didn't carry out, meaning they didn't enforce an arbitral award, what would happen? The ICC didn't tell the losing party or the winning party, sorry, to go to court and obtain an enforcement. No, no, no. They said, come to us and we'll spread the word. We'll use our system based on relations. We'll tell all our network that the losing party is not complying with your arbitral award. This is in the rules of the ICC. The name of the defaulting party shall be published in the official publications of the ICC, in those of the national committees, you know, these famous committees I was telling you about, together with the text of the award, so remaining unexecuted. It's just like Arne would do. He would talk to the friends of Florence if she doesn't comply with the deal. And he would tell, you know, Florence is not trustworthy. Don't do business with her. That's moral pressure. That's relation-based governance. Now, the point I would like to make today is that, as the title of my talk really already made clear, that this system evolved towards a system of rule-based governance, a system based on law, a system based on rules, a system that is much more formalized than the initial system. So I'll walk you through, you know, some aspects of what I call this judicialization of arbitration, but I can raise a few explanations and try to locate the historical moment when this happened, okay? It happened at a time when companies face what game theorists like Dixit, when parties face endgame problems. What is an endgame problem? An endgame is a problem that arises at the end of a bilateral relationship. So you know these stories of how sometimes when you rent a house, on the last month, some people don't pay the rent. That's an endgame problem. Why don't people pay the last rent? Because they will never see again their landlord and they don't care. Okay, that's the endgame problem, which doesn't happen if relations keep happening and keep pursuing themselves in the long term. In a small village, of course, relationship keeps going in the very long term, unless there is a problem. And one of these problems in the business world are economic crises, when a company is facing the possibility of just disappearing, the possibility of bankruptcy. And this is exactly what happened in the 1930s in the context of the Great Depression, okay? So we see, for instance, that in the early 1930s, there was a devaluation of the pound sterling, and the pound sterling was still the currency at this time that was used for international business transactions. After the devaluation of the pound sterling, there were many disputes brought to the ICC, and these issues were typical payment issues under a contract. Should I pay you in the current value of the pound sterling, which is worth nothing, or should I pay you in the initial value of the pound sterling, which is worth a lot more? And because companies during the Great Depression were under such financial strain, they started facing this endgame problem, and they started asking for more certainty, for more legal certainty. Okay, and you see here that the stakes growing higher, they were willing to pay the cost of a rule-based system of governance, which increased the predictability of the system. You see that, for instance, very famously in the 1930s, some parties came to the ICC and said, look, we love your system of arbitration, but we cannot appeal this system, and that's a problem for us. As a consequence, the ICC was not willing to create a system of appeal within its arbitration system, because this would be too complex and it would defeat one of the purposes of arbitration. What they did instead is to create something that still exists. And if you have experience in ICC arbitration, you have seen that. It's the famous scrutiny of draft awards by the ICC Court of Arbitration. When arbitrators issue an award, before the award is released to the parties, it must go through a scrutiny by the ICC Court of Arbitration. And the ICC Court of Arbitration makes sure that, there are rules, as to what they can review or not. The creation of this system dates back to the early 1930s, when parties were asking for the ICC to increase the legal predictability, of ICC awards, to make sure that they were accurate. Okay, that they didn't do mistakes of law. So there were lots of discussions about the scope of the ICC scrutiny, and I can come back to that, but this comes from this time. Around the same time, 1933, parties wanted to have provisional measures. Provisional measures are typically something you need when you're facing a difficult situation. You want a provision to make sure that if you win the case, you will get your money, or you want a provisional measure to make sure that the other party stops behaving in such or such way. You need more certainty because you are facing a difficult situation. It's the Great Depression. Your company is going to disappear if you don't win this case and if you don't get your money back. Another issue that arose during this time period is the publication of awards. Parties wanted awards to be published. It's interesting, something that has been largely forgotten, but the ICC started publishing arbitral awards at that time and continued for some time because of this issue of legal predictability. The goal was really to build a legal system. They wanted arbitrators to be able to look at the ways in which previous arbitrators had decided such or such issue. And if you look at the old issues of this journal, which is called World Trade, that was the official journal of the ICC, you see extracts of these old arbitral awards. So one issue, one explanation is this endgame problem. Another is the gradual demise of relation-based governance. For instance, in 1955, the ICC tried to put pressure on a losing party that refused to enforce an award through the UK National Committee. The UK National Committee refused. They say, we're not going to do that because we're scared of being sued for libel by the losing party. And we see, for instance, the Secretary General of the ICC saying that moral pressure is inefficient or even impossible. And slowly, the ICC supported the legal enforcement of arbitral awards. The ICC was very much behind the negotiations of the New York Convention of 1958. Another untold story that is quite fascinating. The ICC pushed very hard for the New York Convention of 1958 to be adopted and influenced the content of these negotiations. Emergence of rule-based governance, we see it with arbitrators acting more and more like judges. We see the growing proportion of legal specialists involved in ICC cases, and we see the emergence of rules of independence and impartiality that didn't exist at the early stages of the system. Remember, in a relation-based system of governance, you're not picking Arne because he's impartial and independent. You're picking him because he knows both parties. You're picking him because he's not independent. You are picking him because he has knowledge of the two villages in which the two parties are conducting their business. Slowly, as the system grew and developed from relation-based to rule-based, these rules of independence and impartiality grew and became stronger and stronger over time. You see also the emergence of jurisdictional challenges, another sign of the legalization of ICC proceedings. The first jurisdictional challenges date back to 1951. The application of law rather than equity. If you look at the first arbitral awards of the ICC until the 1950s, 1960s, you don't see any reference to any law. It's all equity. It's all party A, just behaved in bad faith, kind of like very kind of blurry. Arbitral awards were very short, couple of pages max, okay? It has developed, it has become more and more legalized, okay? And fast track emergency arbitration. So the evolution, and I'm going a little faster to come to my conclusion and leave place for questions. The evolution in ICSID arbitration is a little different because the system of ICSID was created much later, and I think it was already emerging at a time when the behavior of parties were quite different. And a lot of the procedures of commercial arbitration were kind of migrated towards investment arbitration. And a lot of the people who practiced investment arbitration at the beginning were in fact people who had acquired knowledge of arbitration in the commercial world, which had some unintended, probably negative consequences. What is noteworthy is that the conciliation system of ICSID never took off, just like the ICC system didn't survive. 13 cases submitted to conciliation as of 2023 against 900 cases submitted to arbitration at ICSID. And you see still a push towards the rule-based system of governance. You still see a judicialization of the system of ICSID arbitration. You see it, for instance, in 2006 with stronger duties of disclosure concerning the independence of arbitrators. And we have talked earlier about how it shows the position of arbitrators that is evolving and changing over time. The admission of amicus curiae briefs from non-disputing parties, something that would be completely unthinkable in the past, allowing the public to attend hearings, early dismissal of cases manifestly without legal merit. Procedures that are more and more complex and more heavy, and that push ICSID arbitration on the path of a rule-based system of governance. Now, as I said, this is a continuum, and there are, of course, contradictory kind of moves on this path. None of these systems of arbitration are solidly grounded in one of the two sides of the model. I think they situate themselves somewhere on this continuum. But this evolution raises an important question concerning the transformation of international arbitration and the fact that arbitration as it is today is very different from what it was in the past. And the reasons why arbitration have been so successful might be less and less obvious as the system has been evolving towards a rule-based system of governance. So the question that I raise is international arbitration losing its appeal as it is evolving in that way? These will be really my final words. If you have any interest on these topics, you can take a look at a book I published in 2017 on the topic, The Evolution of International Arbitration, with Alex Suite, or the first chapter of the Cambridge Compendium of International Commercial and Investment Arbitration that is coming out next month, I believe, and which reflects these discussions I had today. So thank you very much, and I look forward to hearing the questions. Thank you.